Hi, Music 595 students. I want to let you know a couple of things right off the bat. First, I am violating copyright law right now because this is playing beside me. This is from the 2005 film of H.G. Wells' War of the Worlds. But even though I'm pleading guilty to that, I am claiming fair use for educational purposes. I'll explain that to you as we move on here in this little discussion about copyright law. It's such a thorny, crazy thicket of challenges, claims, rights that are competing and so forth. I think you know this, but let's just stipulate before discussing this further, we all probably violate copyright law every single day. And that's not okay, but it's part of functioning in human society, and we'll talk about the ins and outs of it. I think we should all be and can be more careful about it. And so, first of all, you got a handout talking about the 6 rights of a copyright holder. Now, when you create a work, you make a work, assuming it's not violating someone else's copyright, you own the copyright to that work. You don't have to file it with the Copyright Office, the Library of Congress. You own the copyright to that. Now, it helps legally if you do register that, because if there's any question in law, someone else may say, hey, I already copyrighted that thing, and then you could have problems because they'd registered it and you didn't, whatever. I've seen a lot of cases of that in my trench experience in this matter. I'm not a lawyer, but I do have a lot of experience in this realm. But if you own the copyright, you have 6 rights reserved to you. The 6 really divide into 3 plus 3. And let's call those 3 RDD and PDD. Those are the initials I'm going to give to each. The RDD are, first, reproduction. You have the rights to reproduce that work as much as you'd like. And the people that own the rights to this film can make as many copies as they want, or not make as many copies as they want. They don't owe it to anyone to do anything in that regard numerically. It's all up to them. They own that right. The next thing is derivation. So reproduction, derivation meaning they can make derivative work, so they can make all the sequels of this that they want to, if they want to make a musical about it, and so forth. If you want to make a painting based on a scene in this movie, you're violating copyright because they have the rights to derivative works, and so forth. We'll talk a little more about that later on, a special category of fair use in that regard. The next D here is distribution. So they have the right to send this film out in any way they want to, or not. They can keep it to themselves, say, you know, we've decided to stop distribution on this, and you don't have the right to say, you know, there's not enough copies around, I want to share this with my friends, whatever. That's a violation of copyright if you were to execute that plan. So don't do that. Now, that's the RDD. The PDD, the next 3 in these rights of copyright holders, have to do with performance first. That's the P. And the law actually specifies all the different kinds of works. You know, it could be a work of music. It could be a pantomime. It actually uses that in the law. It could be a play, of course, a recitation of some kind. You, as a copyright holder, of that work have all the control over the performance of that performative work. And you can decide when and where it gets performed or doesn't. So if you want to perform a particular play that's in copyright, you have to have the permission of the copyright holder. The next thing is displaying. And so this would particularly be, could be pictures of the play, but more often than not, this has to do with artwork. I have, for example, artworks that I've purchased from BYU students. I own the work itself, but I don't think that I really own the copyright to that work. Can I show that wherever I want to without their permission, or publish it, perhaps in a book? I don't think so. It's a little dicey, and different lawyers would probably tell me different things about that. The last D here is for digital transfer. This has to do with basically with the internet age, where you're transferring recordings, specifically dealing with audio recordings of musical works. And well, you have experience with this. The people who do this, the sites that do this on a legal basis, are paying licensing fees to do that, so that there's money coming in and the royalties will be distributed to the copyright holders and so forth. It's very complicated. I can tell you one experience of mine. I was the keynote speaker for the Association for Mormon Letters in 2015, I think. And in the course of that address, I played a recording of a work of mine. It was from a CD that I had been the producer of. I'd raised the money to fund it, but it was on the Tantera label, BYU's label, one of their recording labels. And there's an automated system on YouTube, and they ran it through the system, and Tantera's, artificial intelligence, whatever, picked up this recording that I had played, 1.5 minutes of, said, oh, we own the copyright to that, because they did in fact own the copyright to the recording of that work. And so YouTube challenged me on it. My defense was that, well, actually, it's my piece of music. I wrote it. I produced the CD, and I was using a small portion of the work only in this, and it was for educational use. Now, this brings us from the rights of the copyright holder to fair use defenses for violation of copyright. Just want to point out to you, fair use is not a right. Fair use is a defense for infringement of copyright, all right? Fair use, there are really 4 criteria in evaluating claims of fair use. The first has to do with the purpose and the character of that use. I mentioned educational. Education gets a great deal of latitude in the use of copyrighted works. And I'm hoping that what I'm doing here, having this playing in the background, is really mitigated completely. Education is a mitigating factor for my use of this as a backdrop. I think it is. And I'm doing this for a class specifically. Educational use is not a defense per se. It's not ironclad, because you might be a motivational speaker and you might be copying pages from Tony Robbins' books or something and distributing them. Well, you're educating, but you're not really using this appropriately, particularly if you're making money off it. So educational involves money a lot of times, and that can be a problematic issue. But generally, if you're working for a public school or a university, private or public university, you're in pretty good shape. depending on the number of copies you make, what you do with them, and so on. That takes us, by the way, from let me just say one other thing actually about the purpose and character of use. In this country, we give a great deal of latitude towards parody. This is part of the American character. We have always liked to, from before the nation was even born, make fun of things. And if you were to do a parody of, say, War of the Worlds, that's given a lot of credit for fair use. So parody is it's itself it's kind of a special category when it's talking about the nature and the character and purpose of the use. Now, there's also the nature of the copyrighted work itself. Maybe two categories here to think about. One is fact-based versus literary. If a work is based on facts, you can't copyright those facts. You can only copyright the unique expression of ideas. So, for example, if I were writing a book on War of the Worlds, and H.G. Wells, who wrote the original story on which these movies that have been made from it is based, I could find out from an encyclopedia or Wikipedia or any number of books about H.G. Wells, when he was born, who his parents were, where he grew up, those sorts of things. And I'm not violating copyright at all. And I don't have to cite those sources even. It's good if I do. That would be the scholarly thing to do, of course, and the ethical thing. But you can't copyright facts. You have to copyright unique expressions of ideas. Now, what those are can be tricky, but definitely the bias in favor of copyright works is towards literary works that are about the poetic or the eloquent or something like that. You know what I'm saying? I can't copyright, in this regard, I can't copyright a scale, a musical scale. I can't do it. The way I use that as a tune, for example, I might be able to copyright. Now, if it sounds like a bunch of other tunes exactly the same, then I have a little more trouble with that. We'll talk about that maybe a little bit later when we talk about Led Zeppelin and Stairway to Heaven. But the nature of the work, fact-based versus literary, that's a nice sort of dichotomy to think about. The second thing in this category of the nature of the copyrighted work is published versus unpublished. And this is really a huge category because things that are published are very controlled by law, and there are actual dates involved with when things move from copyright into public domain. We'll talk about that in a minute. But unpublished works have to do with the life of the author plus several decades. That has changed through the years. I've had to deal with that, negotiate that. I was using some unpublished material, for example, in a book on Henry Cowell. It was written by his mother. And she passed away in, I think, 1915, 1916. And so that unpublished work of hers was, in fact, in the public domain. And then because of the Sonny Bono Act, you can read about that somewhere else, it went back into copyright. And so I had to deal then with the head of the estate of Henry Cowell's widow and so forth. So unpublished work, really tricky. You can read more about that in the Salinger case. So just Google Salinger copyright case and read about Diane Middlebrook's problems with citing letters by J.D. Salinger. There wasn't much to the citations themselves, but it was problematic because Salinger could say, I am a noted author. My words are worth something, and my expression is unique and uniquely valuable. And that, by the way, is all I want to say about published versus unpublished. But the next fair use criterion is the amount of the work that you're quoting. Now, a sentence here and there, particularly in an article, whether published or unpublished, you're probably okay. I've encountered this many times in works that I've written, particularly dealing with Mormon leaders and so on, when I've done biographical or historical works there. I may have trouble quoting a paragraph as a block quote from that's unpublished, by the way, from some leader, and the church says, oh, we own the copyright to that. We have to give you permission to use that. So I may say, well, you know what, this one, I'm not going to quote the whole paragraph. I'm just going to pick a few words here and paraphrase the rest. You have to negotiate that sort of thing. The amount of the copyrighted work that you're using is very important. There's no specific fraction to consider. Here, it's not like, oh, yeah, I can use up to 1/10 of or something. Sometimes people say that. It's not true. You could use a very small amount of something, and it might be what in law is called the heart of the matter. So if you had a 10-page article and you quoted most of one page of it, but that page was the page that was the really important thing, then that's different from one page of something that's introductory and maybe wasn't the heart of the matter, so-called. Now, I think of a single line that to me is kind of the heart of the matter. It's the last line of The Great Gatsby, F. Scott Fitzgerald's amazing novel. I believe it's still under copyright. I have to check because the date for public domain is beginning to advance now. But the last line of that book is, so we beat on boats against the current, borne back ceaselessly into the past. It's one of my favorite lines in literature. Well, for me, it's sort of, that's the heart of that. That is the great line in Great Gatsby. But I can quote that to my heart's content. And there's no copyright issue because it's one line out of a whole novel. But it's a really important line. So, you know, the amount of the work, that's critical. Make sure that it's the proportionality with respect to the heart of the matter is correct. But with musical passages, this can be really tricky. I'll give you an example. I've published a rhythmic figure, for example, from a piece of music, and I felt like I don't need to get permission to publish that. I transcribed it. But if I put the pitches with that from this passage, more problematic. If I have a tune plus the accompaniment, that's more problematic as well. I had to negotiate with the estate, well, actually, I don't even know what it would be, but the corporation that owns the material by the group The Doors, because I had transcribed some solos from a live concert of theirs from the song Light My Fire. Published it in my book, 60s Rock, but I had to get their permission. They charged a fee to use it and said, this is good for 1,000 copies or something like that. And we were done with it. So usually, by the way, copyright damages or the requirements for the use of material involves some kind of money. Damages, by the way, means money. That's what that means basically in law. Okay. The last thing that's a criterion for fair use is the effect on the market of the original. So for many things, take a popular CD or an album of some group. Well, if they have real marketability, and I'm making copies of it and giving them away, let alone selling them, I'm hurting their ability to sell them themselves. I will say that for some of us who write very unpopular music, And I know a lot of composers, sort of avant-garde experimental composers who are in this category, will say, well, actually, I'm fine if you make copies of it because I want to get my music out there. And if you're attracting an audience to it, that's great because I'm pursuing audibility. I'm pursuing knowledge of my. So that's a marketability thing. A popular artist may be saying, hey, you're hurting my income. The unpopular artist may say, and I know this from actual experience with myself and others, may say, hey, you're helping my income in the larger picture. So just to review there, so you have the 6 exclusive rights of copyright holders, so the RDD, so reproduction, derivation, distribution, and then the PDD, which is performance, display, and digital transfer. Then you have these criteria for fair use, which is a defense to infringement of copyright. The first of those has to do with the nature and purpose of your use of that material or someone's use of a copyrighted work. The second is the nature of the copyrighted work itself. The third is the amount of the copyrighted work that's being used. And the fourth is the effect on the market of the copyrighted work. So I expect you to know those things, to just be able to recite those back, okay? Now, let me just mention 4 more things with respect to copyright. The first is, what's the purpose of copyright? Why do we have this? The original intent in certainly US law is to promote innovation. If someone is creating, they want to be able to profit from and control the work that they've done. And that giving them the legal right to do that does promote more creativity. So then the flip side of that is, so then why do copyrights end? Why do things go into the so-called public domain where they're out of copyright? Well, it's actually the same reason, because you want people to be able to use existing material for the basis of new creation. We can't just all start with a blank slate all the time. We have to say, okay, here's a theme, here's a thought, here's a concept, here's a character if in a play, or here's an image, or here's a passage of music. Maybe I want to quote Beethoven's Fifth Symphony in my new work in one way or another. So we have to have both copyright and public domain to foster creativity. And the balance between those is really tricky. And it's something that, unfortunately, legislators who aren't always the best judges of such things get to decide. And we're stuck with the results. Now, the second thing I want to mention in this sort of coda to the earlier discussion is just the dates that things enter the public domain. With texts and photographs, as of this year, 2020, anything published 1924 or earlier is in the public domain. Published works. Unpublished is a little trickier. I've given you some links and handouts dealing with that. Recordings are more problematic. I don't know what the latest is, but I think it's still 2045 before any recording of anything audible, particularly music, in this country will go into the public domain. There's a couple of possible exceptions to that. This is a really complicated part of the law. I've sent you some charts on this that come from Cornell University that are very good. But essentially, it's very late in the game. And this, by the way, is one of the reasons why many of us sort of have thrown up our hands and said, that's kind of ridiculous that I can't play, reproduce, let's say, or transcribe a recording from 1912, and it won't be in the public domain, enabling me to do that without any infringement until 2045. That's crazy. And so there is a streak in the American character, let's face it, it's the basic streak, the rebellious streak that created this nation in the first place, that says, well, it's the civil disobedience streak, we'll call it, that says, that's kind of ridiculous. I'm not going to honor that particular law about recordings. Anyway, I'm not encouraging that, but I'm saying some things we bristle at more than others in copyright law. No question about that. So the third thing I want to mention here in this coda is, again, I've alluded to this before, look at some cases, read about them. Happy birthday, a great one. Just Google happy birthday copyright. That's a very entertaining story, and happy birthday is now probably out of copyright. It never should have been in copyright ever, in my opinion, and a lot of other legal opinions. That's a whole story in itself. I won't give you more anecdotes about that. Another one is Mickey Mouse. So Google Mickey Mouse copyright, because Disney has been one of the most aggressive in protecting the copyrights of its characters and stories. And I don't fault them for that, but Mickey Mouse is going to go into the public domain. Whether he ever could have been copyrighted, some of us have questions about, but that's another story. In any case, just Google Mickey Mouse copyright. The Salinger papers, I already mentioned, so J.D. Salinger, or just Salinger copyright case. An interesting one is, I think if you Google copyright Rod Stewart's head, you can read about that. There's an article that's a little out of date now because this has gone to trial and there's been some resolution. But if you look up the article called Crooner in Wright's Spat, you'll get a link come up to a New Yorker article that talks about that case and a lot of really interesting stuff with respect to copyright. It's a really great article. And finally, I'll just mention in this regard the Led Zeppelin Stairway to Heaven copyright case, which was just resolved like last week. At least I think it's resolved. It's been so-called resolved a few times. The group Spirit, who actually played some concerts with Led Zeppelin in the late 60s or early 70s, I don't remember exactly what, they claimed that Led Zeppelin had ripped off the opening of Stairway to Heaven from them. Well, there's nothing that's a unique expression musically in that opening. It's a progression that, I mean, you may as well have Bach climbing out of the grave and saying, hey, that's my progression, or Henry Purcell or something. It's an old thing that goes way back into the Baroque. Many groups have used it in many contexts and so on. And for Spirit to say, oh, this is proprietary, this is our unique expression, was kind of crazy. But they pushed this for years to try to get some of that royalty money out of Led Zeppelin's hands from the big hit Stairway to Heaven. So you can read about that case too. All right, let me just wrap this up, because we're pushing a half hour in this recording. It's either too long or too short for this topic. I don't know what. And again, I'm not a lawyer, but I've been in the trenches a lot with books of my own as the editor of American Music for University of Illinois Press, that journal from 2007 through 2010, and cases where I've been infringed on and so forth. This last thing I want to say is, and it relates to War of the Worlds, in fact, every copyright advisor, lawyer, office that I've talked to ultimately will say, hey, you know, it's all about risk management. You have to decide what seems feasible, what's a risk, I'm taking a risk when I use this material, I potentially violate copyright and so on. And that's what it's about. Weighing, okay, where am I in this? What seems right, proportionate to me? I've had to deal with this many times in material I've used in publications of one kind or another. And not in composition so much, but you know what I'm saying? I just have to say, okay, this is worth it. I'll give you an example with our colleague, Dr. Grimshaw, Jeremy Grimshaw. He wrote a book about Lamont Young. And the title of that book was Draw a Straight Line and Follow It. That is the title of the book. But Lamont Young weighed in and said, no, you can't use that because that's the actual verbal score of an entire work of mine from, I think, 1960 or so. Draw a straight line and follow it. And Oxford University Press, to their credit, in my opinion, said, we're going to use it because that's not the unique expression of an idea. I don't think you can claim that phrase and say, that's mine. I own that phrase, draw a straight line and follow it. And so that became the title of the book without, as far as I understand it, Lamont Young's permission. So that's a risk management thing. Would he actually hire a lawyer and sue them for using that title? Well, that's the thing. You have to consider in every usage, what's actionable? Why'd I have to pay? What's the cease and desist letter that could be issued against what I've done here? Or what would I charge against someone else? And the other thing I would mention with respect to War of the Worlds actually pertains to the time we're living in, which is a time of real risk management as far as the coronavirus, transmission from one person to another. The story, War of the Worlds, written by H.G. Wells, it's been in the public domain for decades because it was published originally in 1889 or so, the story. And the way the story ends is the Martians who invade planet Earth cannot be vanquished by artillery or warfare of any kind. They are felled because they don't have the immunity to the pathogens, the microbes, to which we have developed this so-called herd immunity. And so they were all killed. They didn't have the immunity to this thing. Well, we're in a situation now where a new virus has appeared and we're the Martians on the planet, and we have to back off and protect ourselves from this thing to which we have not yet developed immunity. We hope to develop immunity via vaccine and so forth, and over time we'd probably achieve herd immunity like we have with colds, for example, that don't kill us, but we suffer through them anyway. We've negotiated something with these microbes. I've said for a long time, in a kind of a parody of a Bible scripture from the Beatitudes of Jesus, the microbes shall inherit the earth. I really believe that that's true. I think I never heard anyone else use that phrase. I think I have the copyright on it. If someone else registered that phrase with the Copyright Office, then I guess they own the copyright to it. But I don't really care. From my point of view, you're welcome to use it. The important thing is, this particular microbial infestation of the planet will be over at some point. We'll deal with it. We'll develop the immunity. We won't be the Martians who are felled by this microbe. And we'll get back to having to deal with the crazy infestation of copyright law, which is I've just barely touched the surface of it. And any lawyer watching this will say thumbs up for most of it, but I have an issue here or there because that's the way lawyers are. And I thank you so much for spending the time with me on this topic. Please be safe and well, and I look forward to spending some time with you one-on-one at a distance of less than 6 feet sometime in the near future. Bye.